Hi, I'm Nigel Barmer, Research Director of the Victoria Law Foundation, and the VLF and UCI Law's Civil Justice Research Initiative welcome you to the final session of what's been an excellent International Access to Justice Forum. I'd like to begin by acknowledging the traditional custodians of land which we meet today and recognise their abiding connection to this land, its waterways and community. So the Office of the Victoria Law Foundation is on the traditional lands of the Wurundjeri people of the Kulin Nation. It's my privilege to pay respect to their elders and to all generations of Wurundjeri people who've nurtured this land for over 50,000 years and continue to do so today. I also welcome elders and First Nations people from other nations with us today. So, welcome to the third and final session of the forum, which involves big ideas and looking to the future. Some brief housekeeping: only panelists can be seen and heard in the webinar. All attendees' videos are turned off and their audio is muted, but please use the question and answer function to ask questions or up for other questions, or indeed put in your own big ideas. There'll be time to get to these towards the end of the presentation. We're recording the session and we'll distribute it after the event. Anyway, justiciable problems, whether or not they're perceived as legal, are happening to you. They're ubiquitous, and across a life course, they're unavoidable. They can be amongst the most challenging episodes in people's lives. They're not experienced in isolation. They're fundamentally linked to life and significant life changes, people's health, their relationships, their livelihood. Against this backdrop of problem experience is the reality of advice seeking and barriers to just resolution. So we have an access to justice crisis. Access to a just resolution is restricted. For many people or problems, it's simply not possible. And in many places, the scope of services that help to facilitate just resolution continues to contract. Access is also unequal. What you get depends on who you are, where you are, and your legal capability. What you can do depends on the paths to justice open to you. It's also defined by your legal capability. And even where services and forms of resolution are available, there's an inequality of benefits gain. Regardless of where you're sitting, it's fair to say that as a whole, we're dealing with a system that to a significant degree fails to meet needs and is not tailored to capability. It's a problem in need of some big ideas, which is where these speakers today come in. So for our final session, we've assembled some of the leading thinkers on access to justice and asked them to look to the future. What are the big ideas and the major hurdles to overcome? And to that end, I'm delighted to introduce our speakers. So we have Dame Hazel Genn, Professor of Socio-Legal Studies at the Faculty of Law, UCL, and Director of the UCL Centre for Access to Justice. We have Trevor Farrow, Professor and former Associate Dean at Osgoode Hall Law School, York University. Jeff Mulheron, former Director of the Law and Justice Foundation, New South Wales. Susie Farrell, Research Director of Health Justice Australia. Emily Taylor Poppy, Assistant Professor in Law at Irvine School of Law, University of California. And Rebecca Sandifer, Professor at Arizona State University. So without further ado, I'll hand you over to a virtual Hazel Genn.
Well, hi. Very sorry not to be with you in person. I did think about staying up all night, but I decided against it, which is probably a prudent thing to do. So Nigel asked me to start things off this evening, this morning, whatever time it is in Sydney, to come up with a few big ideas on access to justice looking to the future. And unsurprisingly, I've been thinking about this quite a lot during the pandemic and, of course, during its syndemic nature. I've been thinking about it even more as we move into what is hopefully a post-pandemic world in light of the extra challenges for low-income and vulnerable groups, plus the decreased public resources available for legal support. So I have been thinking quite a lot about it. I'm not sure in the end that I've got many big new ideas. So I'm sorry about that, Nigel. But I do have a few things to throw out for consideration, which flow from the work that I've been doing recently. The work that I've been doing for over 30 years on unmet legal needs, and more recently working closely with the health sector on health justice partnerships. What I also wanted to say is that I think that this is a time of unusual opportunity for legal advice and support services, because I think the pandemic has shone a bright light on the health impacts of social and economic inequality. So I think there are opportunities here which might not have existed in the past or exist in a different way at the moment. And I think that we in the Access to Justice community need to be taking advantage of that. So in terms of ideas, I think I've come up with three. The first is to remind us that access to justice is not an end in itself. It's a means to an end. So for the most vulnerable and those with the most complex challenges, it means access to entitlements and protections provided by law, designed to mitigate deprivation, hardship, and injustice. So we need to underline what access to justice is for and how we can best achieve those objectives for different groups, and especially those who face the most significant barriers to access to justice and the most complex challenges. So that's my kind of first, it's not a big idea, but it's a restatement of an existing necessity, I think. The second thing I want to say, I want to talk a bit about what we've learned from years of legal needs studies. We've learned loads of things, and Nigel can talk about that probably forever, as can I. But an important and consistent piece of learning is that we need to find better ways to get in early. We need to avoid problems from becoming crises and ending up in court or tribunal processes. So the importance, I think the legal needs studies have demonstrated the importance of acting early, getting in early advice, and also helping to break, hopefully, cycles of deprivation. We shouldn't be, I don't think we ever were, but we still shouldn't be expecting people to know their rights and entitlements and expecting them to find their way to the services that they need to support them. We need to get the services to where people are already going for help, and we need to work in partnership with those services that are already providing support to people facing challenges, and to work in partnership with those services whether they're working physically or remotely. And I think that health justice partnerships, note my background, that health justice partnerships are a good example of that kind of partnership working. And I'm sure that Susie will talk more about it, and I would have talked endlessly about it if I was there in person. Third thing I want to say is that we need to look at the focus of access to justice activity and the opportunities offered by technology in order to try and be a bit more effective in how we provide our services. We can use technology to simplify forms of review and redress as far as the legal system is concerned. But we can use technology to increase the reach and effectiveness of our legal advice and support services. Now, to do this, we need to focus on what the private sector would call customer segmentation. So we need to look at potential capability, and I know that Nigel's been looking at that a bit. We can provide better online resources for those people who are capable of self-serving if they have the right information, if they have the right signposting, and if they're getting targeted support. But we can also use technology to be smarter about the provision of legal advice and support services for other groups, the harder to help groups. Technology can expand the reach and effectiveness of those services who support groups who are hardest to help and the least able to self-serve. So I think that there are genuine opportunities there, and we need to, and the people who are involved in providing those advice and support services need to think about how they can use technology to do more with less, because I think in the current and the future economic environment, there's not going to be an awful lot more public funding for those kinds of services. Another important issue related to technology for now and for the future is to use data to demonstrate the value of legal services, and also the counterfactual, the downstream costs of not investing in legal advice and support. I think that we in the Access to Justice community are in the dark ages on this by comparison with health services research, and we suffer in the battle for public resources for free legal advice and support precisely because we cannot demonstrate to the satisfaction of policymakers the value of what we do and the costs of not providing the services that we're able to provide. And this leads neatly to my last point. I'm not sure if it does lead neatly to my last point, but I'm going to make my last point. And this is my most iconoclastic suggestion. And my suggestion is that we consider ditching the terminology of access to justice. I think it is terminology that is meaningless outside the legal profession and justice system. We need to get outside of the legal echo chamber if we're going to be able to achieve the potential that I think we have for mitigating social and health inequalities. I've been talking to people involved in public health and health inequalities services, and I really think that we're all trying to do our best for people facing complex challenges, but we're often using different frames of reference and, most importantly, different vocabularies, which I think gets in the way of making the most of opportunities for partnership working to produce better outcomes. Health sector people, including the likes of Michael Marmot, simply do not have legal or justice in their frames of reference. They don't understand what we're talking about when we speak of unmet legal needs or health harming legal needs. I spoke to Michael Marmot recently about social determinants of health, and he was saying, I've really never thought about legal in that context. I know that he did something for Health Justice Australia recently, but he admitted to me that he really never talks to lawyers and he doesn't think about it in those terms. So I think we need a new narrative around the potential of legal advice and support to mitigate hardship and inequality and promote social justice. Now, lots of people in the room will say, well, we've always been doing that. We know we didn't. We know in the legal services community that we know that legal services are part of the solution to dealing with disadvantage and health inequalities. But we need that to be understood by people outside of the access to justice community. And what I would end with is to encourage people to think about ways in which we can reframe what we do, not do something different, but reframe what we do in a way that sees us as part of the solution rather than some kind of esoteric and misunderstood part of the problem. And with that, I will end. I wish I was listening to the rest of the symposium. I hope it goes well. And anyway, thank you for listening. Thanks a lot.
Hi, everyone. I'm going to jump in now. My name is Trevor Farrow, and I'm coming to you from Toronto, Canada. And I'm going to pick up on, I think, Hazel's second last point and develop that. And specifically, sort of riffing on it a bit, I'm going to use my couple of minutes to argue for widely accessible or ideally universal legal care. And the argument I want to make is based on the idea that doing anything else is inconsistent with what we currently know about justice. So very briefly, what do we know? We have a good sense of people's everyday legal needs and their paths to justice and how they address and don't address their justice problems. And that comes from the work of Hazel and Nigel and Pascal Pleasance and Becky and Ab Curry and others. We know what those needs cost, given the work of Nigel and Pascal and Becky and some of our work and others. We don't know everything about it, and we need more, as Hazel has said, but we know something about the costs. We've also got a pretty good sense of some of the non-financial individual and collective costs of inaccessible justice, health impacts, added social assistance costs, lost housing as a result of experiencing justice problems. We also know that typically, not always, but typically people do better and they get better justice results, and their experience with the system is better when they get legal help. And so we therefore have a pretty good picture of current costs, service gaps, and funding needs. We need more data, but we're not without data. And then in terms of cost benefit analysis, we also have a pretty good sense of the return on investment if we do invest in justice, given the work of the World Bank, our work at the CFCJ, and the work of many others. So for example, in US dollars, we know that $1 spent on legal aid has been shown to yield a typical positive return on investment of somewhere around 7 to 13 US dollars, ballpark. We don't need perfection on that either. We know it's a positive return and we know the basic range. So simply put, based on what we know about justice, access to justice, and a lack of access to justice, it makes no sense not to invest in justice. So, notwithstanding our general collective aversion to adequate justice funding, I think it's time to seriously explore the possibility of universal or at least widely accessible justice care in the spirit of those countries who offer universal or at least widely accessible health care. I know not all do. To do so, assuming that ships full of gold are not readily sailing into port at the moment, I think we need to seriously consider the idea of public-private funding partnerships with the goal of robust public engagement and regulation, particularly at the lower income level, essentially a robust legal aid scheme, combined with widely available and expected legal expense insurance for the middle income bracket. Now, I know some countries have a stronger tradition of legal expense insurance, but many, including Canada, do not. I know Quebec has a bit more, but lots of us don't. So while, at least in Canada, we mandate that people buy home and auto insurance, even though way fewer people will have home fires or car accidents, then they will have a major legal problem, we don't seem to get it. We don't think that adequate legal help supported by adequate legal care is important, notwithstanding we know about the cost, benefit, return on investment, and impact. Now, having said that, I do think that doing so requires a strong involvement of the state in terms of ensuring adequate and accessible coverage at the bottom end, while also regulating the kind of insurance and services that can be provided at the middle income range, all in order to ensure that justice continues to be a public good, available to the public and for the public in a way that all members of the public can access in a more meaningful way. So I know I'm not the first to think about this idea, far from it, and I commend the work of Hill and others on scaling justice finance as places to start. However, in the end, I think we will ultimately save, not spend, money on this idea. Further, I think everyone will win. The lawyers, who can be funded to provide legal services to the massive amount of current unmet legal need, will be happy. Regulators can decide how much regulation or deregulation makes sense in order to maximize the benefit of this kind of scaled legal care. People who need legal services, essentially all of us, will be able to get much needed legal services and the kind that we need. The insurers will be happy and we can regulate that sector. And society at large, which continues to pay in terms of the knock-on effects on health and other social and related services that result from our current lack of access to justice, will benefit socially and financially. And the best part, we don't need to start again. We can simply start now. In any event, that's my pitch, my idea, not the first, but I'll leave it at that. And I think I may be turning over to Jeff, if I'm correct about that. Thanks for listening.
Thank you. Thank you, Trevor. And I'd like to, and hello everyone, thank you very much for the invitation. I'd like to begin by acknowledging that I'm on the traditional land of the Wallumattagal people of the Eora Nation, and I pay my respects to their elders past, present and emerging, and I also acknowledge all First Nation people participating in this session. I'm going to talk about a number of Australian examples, but I suspect they will have direct relevance to many examples in your jurisdictions as well. One of the things I want to talk about is basically funding, and that's quite a common theme. But basically, it's come up regularly all the time. It's come up in these 3 days, of course. So whether we're talking about taking proven pilots to scale, improving data quality, providing more robust disaster legal assistance schemes, or indeed funding Trevor's suggestion of the legal care scheme, more and better funding is clearly on everyone's agenda of public funding. At the risk of oversimplifying things in the interest of time, I think there are two main ways we can actually get more funding, public funding, into certain parts of the justice system. One is to get a bigger piece of the total consolidated revenue pie. In other words, getting more for justice than, say, and at the possible expense of health, education, housing, and other portfolios. Or secondly, redistributing what's in the justice budget itself. Now, I won't speak about the first one it's beyond the scope of my comments today, but also, and notwithstanding all the great work people are doing in terms of outcomes and that longer term work they're doing on board impacts, I'm not sure that in the near future we're going to have much success there. And looking at Hazel's comments, which I've just seen as well, obviously I think that's a longer term, their final suggestion. We're talking longer term there. So let's focus on the short term. And I want to talk about redistributing the justice budget, which is actually something we can do ourselves. Now, how are we going with our distribution? Are we distributing our justice budget appropriately? Well, let's have a couple of Australian examples. Bell Resources in 2014 Productivity Commission, the Bell Resources case, probably one of the longest running cases in West Australia, was basically a battle between insurers and a bunch of banks, cost the state at least $15 million to run, and they recovered about $700,000 or $800,000 only in court costs. In other words, less than 5%. It eventually settled confidentially, so you couldn't even argue that there was much benefit in terms of contributing to the shadow of the law. Now, that $14 million that wasn't recovered could easily have been spent on other things. For example, the annual budget of the West Australian Aboriginal Legal Service, which represents about almost 20,000 criminal matters a year, is only about 12.6 million. So it's more than that. Now, what Bell Resources might have seen to be a rather extreme example, but in fact it's probably not. I'm sure we can all think of many other cases in Australia. The Reinhardt family, one of the richest families in the country, if not the richest, had a family dispute for a few years back, which trying to decide which child got which $1 billion. I don't think anybody was going to walk away ever without at least a couple of $1 billion each. But I wonder how many taxpayers' dollars were spent on that. At a lower level, perhaps less extreme, but probably more frequent, I had lunch a couple of years ago with a Court of Appeal judge here who was on day 3 of a appeal matter, and the amount litigated over was $50,000. Now, the pathway to get to the Court of Appeal for a $50,000 matter is, I wonder how many taxpayers' dollars were spent. But it's not just civil litigation we're talking about. Between 2007 and 2020, based on Commonwealth funding, Victoria Legal Aid spent each year about $4.5 million on a handful of terrorism-related cases. And that's about exactly the same budget per year of the Victorian Aboriginal Legal Service, which represented Aboriginal clients in about 1,400 matters. Now, I'm in no way suggesting any form of malfeasance or anything. I think people just apply the system. I'm just using those as examples about the system and its problems. Okay, so my thesis is that the system is unable to make the distributions itself, the redistributions itself. There are many initiatives looking at trying to recover court costs and so forth. I just think that they are often too narrow, too complex, too hard to implement, and are hotly opposed anyway. So my approach would be this: that we take the present system we have operating in Australia for disadvantaged people applying for legal aid, where they must apply and they must pass a means, a matter, and a merit test to get even a small grant of legal aid. I suggest that we apply that to any allocation of public funding to the justice budget. I think that's perfectly manageable. I mean, at the moment we ask disadvantaged people to do it, but we don't ask Bell Resources and others, those people who can afford teams of lawyers and accountants to manage the process, to go through a similar process. Importantly, there'd also need to be an annual reporting mechanism in general terms in place. That way that we'd have some information each year, so the public, the profession, governments could see each year the proportion of money going to which parts of the justice budget, and over time we'd see changes. All right, there'd be some real advantages, I think, in this model. For a start, the sky wouldn't fall in, nothing would change overnight, but there'd be greater transparency, as I've just mentioned. People would see what proportion of the money is going to which part of the justice need. We would have mindful or intentional decision-making for perhaps the first time in terms of which part of the justice budget is spent on. We wouldn't have those disparities of cases like Bell Resources. Over time, I think we'd see a decreasing proportion of money allocated to support high-end private litigation and an increase allocated to perhaps the everyday legal matters. I think we'd see a decrease allocated to those private litigation matters where, when they settled out of court, there was actually no public benefit because there was no contribution to a shadow of the law argument or anything like that. I think actually there'd be increased work for people at the suburban solicitor, community legal centre end, where they'd be better supported by whatever it would be. I think there'd also be some economic incentives where there become, better awareness about the cost of possible solutions, and solutions would be designed to perhaps fit within the allocations available. And I might add, this might even allow us to fund a legal care model in due course that Trevor was suggesting. I'm sure that there'll be many who will think that I'm something of a or who move from my excommunication, but that's my suggestion, and I thank the organisers for the opportunity to think aspirationally. I'll now pass over to Susie Farrell.
Thanks so much, Jeff. And thanks to the VLF and the UCI teams for the opportunity to speak with you respectfully from unceded Gadigal land. I offer an idea to increase our capacity and opportunities to improve access to justice, a bit like Hazel, by thinking beyond the term access to justice, to revisit what's at its core, to think who else shares this agenda and what do they offer, and to identify opportunities to work with them towards this common goal. So access to justice is widely understood as the ability of people to uphold their rights and seek redress for their grievances. And framed in these terms, access to justice is squarely the business of the legal and justice sector. We absolutely think about access to justice for beneficiaries, but the phrase centres the work of lawyers, our sector, as the work that makes that difference. But let's also ask, what are the things beyond legal assistance that help people solve their legal problems? What beyond legal process supports procedural fairness? What else who else shares our concern for justice? And how do we harness what may be parallel efforts to a shared force for impact? Let's unpack access to justice. Implicit in the definition of access to justice is the recognition of inequity. Some folks have less opportunity to uphold their rights and seek redress than others. Just as some, often the same folks, have less access to safe and secure housing or adequate income, are more socially isolated, have poorer educational opportunities and outcomes, are at higher risk of crime victimisation and incarceration, at greater risk of poor health outcomes, and poor individual and community well-being. And addressing inequity is not just the business of justice. We see it in health, for instance, with a focus on the social determinants of health and health equity. We see it in communities as people seek fairness, voice, safe and secure lives, improved well-being. So thinking beyond, or even for a moment letting go of the term access to justice, to describe our important work towards equity, broadens the conversation and perhaps better centres people and community. It invites others with shared interests, but a different set of tools, strategies, connections and options to respond to what we know are complex and interrelated issues. What any one of us does as individuals or as a sector makes a contribution, but of course is not the sum total of what is needed. So there's actually shared interest in harnessing the work of each other. And we have heard at this forum that this work is already happening. So what does it look like in practice? It's in our efforts to redesign our approaches and systems to fit the needs and experience of clients and users. Not just for, and we saw that with the CRT and the IT solutions. Not just training users, for instance, through community legal education to work within our existing set processes. So if you like, it's building our capability to reach and assist, not just people's legal capability to participate. It's the work in partnership and collaboration with health services, schools, the social assistance sector, other research disciplines, IT experts, and the community. Others with different expertise and experience, but with a shared vision to address inequity and improve lives. It's putting people and their well-being at the centre of our practice and working with them and others to engage the right tools at the right time and in the order that works for them. Sometimes it'll involve putting down the tools of justice, even just for a moment, to make room for the expertise of other disciplines and sectors. It might involve throwing some tools out altogether to create new, more fit for purpose ones. It's inviting others into our conversations about the service and system challenges we face. Think about who else might have been in our virtual rooms over the last few days if it had been an international forum on equity and community wellbeing. It's taking the opportunity not just to provide our expertise to our colleagues, but to learn from others who are also working around complexity and the people for whom this is their lived experience. It's defining success as problems solved, as lives improved and equity achieved, recognising our contribution among others. Access to justice matters, as does the work we're doing to achieve it. But let's not let the term mask the abundant experience, expertise and energy that sits beyond this framing, and that we can use to increase the range of ways that we improve equity and access to justice. So thanks, Emily, it's over to you.
Thanks so much. It's such a pleasure to be here with all of these other panelists. I feel like the kid who got to sit at the lunch table with all the cool kids, and it's a real thrill. Building on some of the themes that we've heard in some of the other comments, I want to focus my comments on making the case for access to justice. And in particular, I want to think about shifting the conversation to making access to justice a movement, so that we can garner public and political support to make the interventions and innovations that my fellow panelists have mentioned move from a world of dreams and hopes into reality. I was motivated to think about this by the moment that we're in, and I speak from a US perspective, but I suspect that what I'm feeling will resonate with those of you from other places, that it's a very complicated moment, where on the one hand, there is a sense in which there is a push backwards and a retrenchment. But on the other hand, there's this possibility that we might be moving forward to true and more structural, dramatic change. And so I don't think it's clear exactly at this moment where we will go, but my hope is that this moment offers an opportunity for real change, and that access to justice might be able to seize this moment in our favor. And I'm optimistic in this because of the engagement that I'm seeing about access to justice from so many different stakeholders, and many of which have been mentioned or referenced during the conference thus far. I look at, in the US perspective and context, movement at both the state and federal level that's bringing issues about the relationship between government and the public, services to citizens, into new light. And there are new pressures for the government to actually consider how they work with citizens in the delivery of benefits and rights. I think there's also excitement because of the relationship of NGOs and IGOs and the work that they're increasingly doing in the access to justice space. And not just in terms of the research that they're doing that highlights really important justice issues, but also in the legitimacy and voice that they give to these concerns. I'm also optimistic at this moment because of what we're seeing in terms of the regulation of the profession. And this is especially true in the US context. And I'm sure Becky will have more to say about this in her comments as well. But it's an exciting moment in that we're seeing changes about who is doing the regulation, and additional reflection on the fact that maybe the people doing the regulating and lobbying for the ongoing monopoly shouldn't be the same people. We have movement in terms of what we're allowed to do in terms of delivery of legal services, and who can be doing that, and also the entry of how we get people into those roles. I also think the push from legal tech makes this a really exciting moment of possibility for access to justice, which is not to say that I think legal tech solves all problems. I think everybody here has some sense that there's also potential pitfalls, but there is potential. And I think if we can leverage points of agreement with legal tech providers, and if we can creatively use legal tech in support of an access to justice agenda, there's real possibility in this moment. And I'm also excited as somebody whose day job is as a professor in the academy, that I think educational institutions can also play a role here. As the last panel discussed, There's a role for legal education in shaping access to justice. And just even having that panel is itself evidence of a conversation that is happening in terms of supporting shifts in new directions. I also have to note in the American context, my thankfulness for people like Becky, who have been working with the National Science Foundation and the American Bar Foundation to provide new opportunities for scholars in this area, which is really fundamental to creating a field of access to justice that can help to promote this agenda of equality and justice for all. But there's one more constituency I think we need to work on, and that is the public. I'm teaching a seminar on access to justice this semester, and I asked my students to help brainstorm some bumper stickers for access to justice. These are some of the ones we came up with. But as I think about it, I don't think I've ever actually seen a bumper sticker about access to justice. And I think that's an issue. Whether we want to continue to call it access to justice, or we want to take the suggestions of Hazel or Susie to move toward new branding and framing of what we do, I think it's important that the public understand the value that access to justice and enhanced equality can provide. So I want to end today by saying I'm optimistic in this moment, and I hope someday soon to see some bumper stickers for access to justice. And now I will hand it over to Becky.
Thanks, Emily. I'm grateful to the Victoria Law Foundation and to UC Irvine for inviting me to be here today and for putting me on such an edifying and stimulating panel of such thoughtful colleagues. The danger of coming at the end of the day is you have to think of something new to say. And I think what you'll find is that a lot of what I have to say isn't new at all. It'll resonate a great deal with some of the remarks that other people have made. And I think the thing that I'm thinking about is Emily's identification of the moment. So I have a suggestion about a way we might respond to the moment. So part of the moment is that if you look around the world, about 2/3 of the world's population, so that's more than 5 billion people, lives outside the protection of the law, and they lack access to justice that's meaningful. And importantly, it's because they're locked out of their own legal systems for a range of reasons. And that kind of lockout is especially paradoxical if you're in a country that aspires to be a democracy. Because in democracies, you have ordinary people who've elected representatives to write laws about issues that we've decided are so fundamental that we should have a collective stake in the way that they're regulated. So things like making a living and having a place to live and taking care of people who depend on you. So ordinary people elect representatives to write laws about those important issues, and then they pay for the administration of those laws. And then paradoxically, they often can't use them. Some of the research that Hazel was referring to, and also Trevor, give us a lot of knowledge about some of why this happens and how it happens, and they give us insight into discovery. They give us discoveries that could help us fix these issues. But I think we would all say there's more that we could know. But I think there's one thing that we can say with great confidence that we do in fact know, and that's that what we're doing now isn't working. So I would say, let's stop trying to do more of the same thing that doesn't work and try something that could work. So let's democratize the law by changing the way we regulate the practice of law. Specifically, let's change the way we regulate law to focus on the outcomes that we care about. So not on who provides services, not on who trains the people who provide services, not on how services get provided, not on who's allowed to make money from it, but on the substantive outcome of access to justice, of resolving legal issues lawfully and achieving just solutions. If we regulate to focus on outcomes, that would be actual public experience with law. That would mean we'd have to have empirical evidence about those outcomes to guide that regulation. And that would mean that the regulation of legal services, instead of being based in tradition or belief or habit, would be based in evidence. And in simply working those regulatory systems, we would gain critical knowledge that could help us change our justice systems so that they're open to the people whose law this is. So we would learn about how to design interventions that are proportionate to need, both the needs of individuals who experience these issues, but also the needs of the common good. And that proportionality is the empirical version of equity, which is a value that democracies hold. We can learn about how to design entry points and connections that are accessible to the wide diversities of people that live in our countries and who are all supposed to be governed and protected by these laws. And in doing that, we would have opened up participation in law, this common thing, in two ways. We would open up who and how can practice it, and we would open up who and how people can connect with it. And that would open up the law to groups and people who right now are completely locked out. It would open up access to justice to everyone whose law this is. Is this crazy and impossible? Strangely, it isn't. And the reason that I say that is if you look around the world right now, there's activity showing us both that this can be done and how to do it. So let's learn from the doers and use what they're teaching us to give people back their own law. Thank you.
Many thanks to all of our speakers. I'm hearing some core themes going throughout the speakers around making the most of limited resources, demonstrating the value of services, acknowledging and working with other human services, encouraging new participants and partnerships, capturing impact, and altering what services look like and what they can do or what they're allowed to do. Linking to this is the idea of law being one of many tools to address problems with many facets, and this idea of reframing the law and its place in the world. So going to Hazel's point, does law and access to justice have an image problem? Do we need to reframe it? Can we reframe how we might describe problems, services, and access to justice as a whole? And perhaps use this new understanding to make long-standing arguments for funding or broader scope, i.e. going to some of Trevor's points. I like Emily's idea of bumper stickers. I'm going to rush out and get an I Love Civil Courts bumper sticker. But my question to start out with really is this an education piece or a reframing? Are we trying to educate here, or are we trying to start again? So if law and access to justice have an image problem, how do we reframe what we do so we might be seen as part of the solution, not what Hazel's referring to as this esoteric and misunderstood part of the problem? So is it a barrier to harnessing some of the expertise of others that Susie spoke about, so adding tools to the toolbox? Hazel's not here to respond, but can I just open it to the panel? So do you agree with Hazel that we need to reframe, or are we going to try and educate to try and tell people what access to justice is? And if we reframe, what's it going to look like? So anyone feel free to jump in.
I'll jump in briefly, Nigel. It seems to me it's both. I'm sort of listening intently to, Emily's point about the movement and engaging the public. I'm thinking seriously about Becky's point about, which feels a little bit more retooling. We may be able to do it as we go, but a little bit more wholesale starting again. And I was really taken by that idea. While at the same time, we may not be throwing everything out. And so that is a little bit of bumper sticker, maybe funding and helping to support what we do have, but in a much more meaningful way. And I don't think they're mutually exclusive. And maybe that's one thing we've been struggling with, is we've been thinking either or, and maybe there's somewhere it's a little bit of a combination of the both. But I'll stop now. I'm sure others have better stuff to say.
Yeah, I think we don't have to lose access to justice just to recognise that there are other conversations going on that use different language. And that, so I guess it goes, when we think about what is, to your point, Becky, about thinking about the outcomes, well, outcomes to whom and what do those outcomes look like? And when we're thinking about complex needs, the things that we call legal problems can be understood from a different lens as a different type of problem. So there may be legal solutions, but there also might be other types of solutions to that problem, or in fact, both sets of tools are required to deal with those problems. So I guess I'm not suggesting we, There's no place for access to justice. It's just that we're not hearing from everybody because it's just not language that others are using.
I'll jump in and maybe first of all say I thought the contributions were all fabulous, and I particularly liked Becky's and Emily. All of them were very good and had that broad perspective. I guess my approach was perhaps a bit more focused on what we could do. Maybe it's my age and and what I've had in the past, but I guess whilst making the case for access to justice and what we mean by that, one of the problems I think we find is that many parts of the justice system almost argue against us. That is the disproportionate allocations of funding that I sort of alluded to, and there's many others, come because the system has, evolved is a good word, probably ad hoc developed in a way, and it's not easy to change. And governments find it difficult to change for all sorts of employment reasons. They've got courts, they keep funding courts, they add a CPI into it. To bring about change, it's actually really quite difficult. And so I guess we have to do two things. We do need that broader vision of that change that all the other speakers were talking about is really important. But in the short, I guess my concern is the empire keeps striking back, and it's how we make some positive, what we can do, whilst the empire hasn't fully defeated us yet, so to speak. Anyway.
I guess I just wanted to also toss out a point that I've struggled with in some of my work, thinking about kind of the institutional design we're working within. And the fact that when we talk about access to justice, we have a root in the civil justice system, which is the judicial part in the US context of the tripartite system, right? And the problem is that problems don't respect those boundaries. Right, and health and human services is over here, and criminal is over here, and we're really up against this this system that is so siloed, and I think that's a real struggle, and I think that's a real tension working against us in thinking about repackaging access to justice as problem solving in a broader thing. And I don't have a total solution to that, but I think that's a reality that makes this difficult.
Well, I want all of Emily's classes bumper stickers. I think engaging the public, at least in policy environments like the one that Emily and I are in, where you don't have kind of a technocratic central government that's trying to figure out how to spend large piles of money, but you have a hugely diverse group of people fighting over tiny little pots, and a lot of symbolic fighting. I think engaging the public is probably going to be more effective if we do so around issues that they already care about, like having a place to live or getting healthcare. And that's related to this problem focus that we're all talking about, because the point is to solve the problem of homelessness or lack of access to healthcare or whatever. And getting funders to see that, getting policymakers to see that, and getting people who vote to see that, I think is a really critical thing.
So just returning to Jeff's comments, it's quite hard to sit in an audience like this and not feel the allure of Jeff's argument. And it's pretty hard to argue that if you're concerned with tangible benefits to individuals and communities, then these limited funds might be more appropriately spent. So is it possible to introduce some balance? What's the route to making it happen? And we had a question from Liz Curran, just saying, does the panel want to explore further Jeff's idea about a wiser use of expenditure of justice monies and the disparity it highlights? And she also highlights that Jeff is very cheeky. So anyone like to respond to that?
I mean, I'll jump in to say, I would love for it to be more known and understood, the choices we are making. You know, we have this Supreme Court quote, sunlight is the best disinfectant. And the idea that if we could truly show these decisions, I think there is something to that. I think there's a challenge, though, in that a lot of the time what I'm arguing for is for the ability for more access to justice work to be those cause lawyering cases that are going to make systemic, substantive legal change. And one of the problems we have in the US is that the Legal Services Corporation can't do that because it's been prevented by Congress from doing that. So I think that's one tension I see, or that concerns me, is that sometimes I want that big litigation to get to the root problem. And how do we make that triage decision?
Jeff, just let me ask, is a reframing of your argument basically, and I'm not trying to simplify it because I think it's really an important argument to make, but essentially what you're arguing for is data-driven expenditures, meaning we look at the legal needs research, we look at the stuff we know, maybe we need better data, but let's assume we've got good data, and say, let's spend the money proportional to how people use it and need the services, and then start from there. I think we're all going to agree that we don't have enough money to start with, and we need to find a better way to fund what we do need. But I think that's your point, isn't it?
Well, no, I go beyond that. I think that's part of it. But I think I've been thinking about, as you know, I've probably spoken to you over a number of years from time to time on issues like this. The current ways, there's been lots of attempts to, for example, increase recovery of court costs and so forth. And there's a whole lot of complexity in there, and people oppose it, and they're saying you can't put a dollar value on justice. Well, of course, there's a dollar value put on justice every day. I guess the point I'm trying to say is at the moment in Australia, and I think in other jurisdictions, a disadvantaged person is asked if you want to apply for a small amount of legal aid, you've got to convince them that you don't have too many means to get it, as in you're limited in your financial resources. It's a matter that will be covered by legal aid, and you've got merit that's likely to succeed. We don't ask that question of the Reinhardt family, or we don't ask that question of the civil litigants. If they can afford to go to court, if Bell Resources, the insurance companies and the banks can afford the lawyers to initiate the action, spend a whole bunch of taxpayers' dollars to help them do that. And so all I'm saying is that we should have a system whereby we ask them all to, before we spend any public money, everyone should pass through a means, and merit test. And there will be opposition. I can see the top end of town saying, "Oh, it's going to impact, going to barriers to justice." Well, I would say this: if that's the case, why are we asking disadvantaged people to do it for the grants of legal aid, when in fact the Reinhardt family, the Bell Resources, and all the other commercial litigants, they can afford teams of lawyers and accountants to negotiate whatever system we put in place to argue for their allocation of budget. They have the resources. And so all I'm saying is we should have a system whereby, over time, where there's two key elements to it. One is that, sure, the courts are still there, but you have to put in your means, merits, matter test. And the court says, well, I'm sorry, Mr. Reinhardt, you have to, or Ms. Reinhardt, you pay 100% of your costs and so forth. It doesn't mean that there won't be matters where a disadvantaged litigant gets fully funded by this system and the other side doesn't. It's a way of getting through. And over time, the sky wouldn't fall in, but over time, I think we would see, particularly with the annual reporting part of it, we would see a realization of, people would say, gosh, did we really spend that much money on the Bell Resources case, and we only spend such a little amount on the Aboriginal Legal Service? The whole terrorism thing, I'm all for dealing with terrorists, but, Aboriginal incarceration in Australia is a far, far, far greater problem in Australia than the terrorism issue, yet the disproportionality of allocation. So I think that we would get some visibility to that. And I think it would then become for the first time, a mindful and even an election issue. It would get that. The public would be aware of it when it came to election time and so forth. So it's an over time thing. So it's not just data. There'd be some data there, but I think in the first instance, it's simply saying, all right, convince the agency that you passed the means, matter, merit test for this allocation of funding. And as always, Trevor, you look worried whenever I suggest this.
I actually think it's a great idea. I think it could have its critics, but I'm not. I'm just exploring what exactly it entails. So thanks for that.
So I think throughout the forum as a whole. In this session, we've seen a number of comments focusing on the power of data and also a call for data. So from Becky, a call for data and regulation focus on outcomes, interventions based on evidence. Clearly, it's a theme I strongly support. Trevor as well has been putting a lot of effort into social return on investment studies, and they feel pretty compelling, right? My questions really is, what else do we need here? How do we get the message across, or why isn't it currently getting across? There was a question from Richard Fife in the chat as well that said, how do we overcome government resistance with already increasing health costs? Is data enough? So that's kind of my question. Is data and evidence enough? Are there other things we need to do? Are there other buttons we need to press?
Bumper stickers, Nigel. That's what we need. No, I mean, I do think there's a public piece to it too, at least in the US. I think data is important. And I'm increasingly convinced that the court isn't going to collect its own, isn't going to do the data piece. We need the legislature to make the court do the data piece. That's where I've seen it work in state context. The legislature mandates some reporting and the court says, oh gosh, we have no idea. And then they miraculously realize they could have an answer. So, but then that brings us back to political power. And so in the US context anyway, I think part of it is still convincing politically that this is all important.
Also, perhaps linking with data beyond our own sector. Again, recognizing that the work we do in this sector has impact beyond the sector. So yes, we need to be able to see the work through data, but we should also be alive to where else it has impact and the data that already exists there.
And is the corollary to that, Susie, that data from other sectors also needs to more powerfully inform the work we do?
So if we don't have any, we're coming up to the hour, so it might be a good time to hand straight back over to Lynn to wrap things up, I guess.
Thank you, Nigel. I think the first duty is to thank all the speakers on this session. It's been a phenomenal way to wrap things up. I've been thinking about the experience of the conference as a whole, and the image that came to my mind at some stupid o'clock last night was the sort of pinball. I've sort of been bouncing and flipping from one conversation to another, and all these ideas and points of difference sort of ringing bells and throwing up lights. And so there's an enormous amount to take away from the conversations that we've had over the last 3 days. And I should comfort you all by suggesting or informing you that there is a move afoot to recreate this experience in the not too distant future. So stay tuned for further opportunities to gather and debate in the vein that we have over the last 3 days. It's been absolutely phenomenal. And I think we all take away, or I certainly do, an extraordinarily rich understanding of the diversity of thinking around access to justice, including, as we've just heard, the validity of the term itself and whether or not bumper stickers are the future. I happen to think they probably are. So I think your students, Emily, have started a movement amongst themselves. We just need global reach now. A bit of a partnership with one of those major, distributors will get it moving. But as you can imagine, conferences like this just don't make themselves. So I think some appropriate appreciation from all of you would be well in order. And if we were live in person, then there would be thunderous applause, I'm sure. My great thanks to Nigel Balmer from the VLF and to Emily Taylor-Poppy from UC Irvine, as I've come to learn to say it. I default to Irvine, which is the Scottish pronunciation. So I actually write it out, Irvine, to make sure I get it right. But to you both, it's been a phenomenal experience watching this germinate and come together to create and to curate this phenomenal conference. And I think the meeting of minds across the Pacific has been something to behold. To the VLF team in the background, who have done an absolutely extraordinary job in terms of the tech masterclass that putting on 9 sessions of an hour each. And as we all know, an hour is a ridiculously short period of time for these conversations, keeping it all incredibly tight and smooth, everybody showing up when they needed to. So to Jackie Matthews and Helen Papadimitriou and Claire Kennedy and Chelsea Brunkhorst, who've held up the back end over the last three days, our eternal gratitude. And to Tennealle Hagland, who has done so much, and those of you who've been involved with speaking and coordinating will have had numerous engagements with Tennealle over the last few months. I cannot tell you the amount of work that sits behind an event like this, and the time zones, the run sheets, the platforms, the tech decisions, the logistics around this are extraordinary. And I cannot also describe adequately Tennealle's patience and grace with all of this. There has never been a raised voice or a lost temper, and I have been in awe of her calm and her persistence and her super competence over this period. It's really been an extraordinary thing to behold. Thank you so much, Tennealle, and rest well. And finally, thanks to everyone. Thank you all for coming. It's been an absolute blast. Go well, and we look forward to seeing you again very soon. And lots of love from the Victoria Law Foundation and from UC Irvine.